Hello, ladies and gentlemen, welcome to Coin Lady channel. SEC versus Ripple. The SEC has filed supplementary authority with Judge Torres today. And how much of an effect this will have is debatable. To be honest, it does appear that this is beneficial to the SEC. Does this new information have the potential to affect the final verdict? Doesn't appear to be the case. I'll forewarn you right off the bat in this video that an attorney has expressed concern that the SEC's filing of this supplemental authority will extend the length of this litigation. I'm not joking. Consequently, there is a chance that this could be the very last stinking delay in this matter, which has already been postponed by SEC so many times I've lost count. Laughable nonsense. However, there is another local lawyer who doesn't think it will cause any delay. And also one of the attorneys. I'm going to go through all the details here and share with you opinion from a couple legal brains in our community. One of the lawyers, however, is confident that Ripple will prevail on the fair notice defense at issue in today's case. This supplementary authority is, in theory, beneficial to the SEC. Therefore, the SEC's filing makes perfect sense. In a separate message, I'll relay a few of points made by Jeremy Hogan, an attorney. He speculated on how well Judge Torres may grasp the enormous significance of this case. And then, he was basically asked, we should have certain rights from the seller if XRP is determined to be a security. That's to be anticipated, right? Because that would generate waves, that's why. So, does Ripple owe us XRP holders anything? I'll let you know what Attorney Hogan said before the judge rules on that if I can. But I do want to clarify something before we go any further. I come from no financial or legal background. Neither legal nor financial counsel is being provided by me. And you should not make any financial decisions based on what I write or say. I'm just a fan that occasionally posts films to YouTube regarding crypto-related subjects for pleasure and as a pastime. James K., an XRP community member and file attorney, gets props and thanks for his contributions. He revealed this new information just this afternoon. This is the SEC's official correspondence with Judge Torres on the SEC versus Ripple case. I don't see why I should interrupt the show to read it, but if you want to, go ahead. The second page hardly has any information. It's conveniently close by. The final line serves as a signature. Okay, that settles it. All you need to know is that on April 7th, the SEC issued a judgment in a matter that had already finished. This just occurred during the last several days. In this case, the Massachusetts District Court agreed with the SEC and concluded that the defendant had failed to meet its burden of proof with respect to the fair notice defense. Since the defendant is referred to in this document as the Commonwealth, that is the name that will be used. I need to know the whole name. Commonwealth Equity Services LLC, or Commonwealth for short, is a registered investment advisor. They're the accused criminal. They lost this case, too. Not only was this case relevant to the SEC versus Ripple case because it was yet another example of a defendant's fair notice defense failing, but also because the defendant therein made reference to a different case, the Upton case, which I discussed at length on this channel. In addition, Ripple cites the Upton case as part of their fair notice defense. Thus, there is a connection or shared ground. That's why the SEC decided to provide the supplementary authority today. But how much does it really matter, if at all? That info from attorney filing was retweeted by XRP community member and lawyer Bill Morgan. Also, earlier today he gave his thoughts on the matter in the form of the following writing. All right, James, thanks. The SEC's letter was brief and to the point. In a prior decision on a move for summary judgment, the SEC ruled against Ripple on the basis of the fair notice defense. Similar to Ripple, the defendant in this instance lost a reasonable notice defense in which it relied on Upton v. Sech. The court ruled that a case from the 1960s provided adequate warning to the accused. Therefore, it claims that Ripple had ample warning in light of the Howey decision and subsequent precedents. At first glance, at least, this case appears to benefit the SEC. Still, folks, let's be sure one key distinction is understood. This is a whole different sector, and researchers were surprised to discover a rather high level of clarity inside a sector that has existed for half a century. Right? As if that weren't enough, Bill Morgan goes on to say that the Massachusetts District Court's ruling isn't legally binding. Therefore, Judge Torres need not give it any thought at all. I have faith that she will give this some serious thought after reading it. However, this need not change anything about the verdict. That being the case, the judge's discretion is absolute. I'm merely stating that, legally speaking, Judge Torres doesn't have to take this into account when making his summary judgment decision, as Attorney Morgan explains. She need not bother. Let's pretend she's almost finished with her summary judgment, decision, draft, etc. There's no reason for her to return. It's kind of like, hey, take this under advisement if it's so far off from what she was writing that she doesn't need to recreate it. That's closer to the truth. After Judge Torres heard this, Attorney Morgan argued that it was not a final determination. And you can expect Ripple to try to set this scenario apart. Distinct evidence. Also, etc. This is not a complicated task. The court is not required to address the existence of a novel asset class or the potential market distortion caused by the Hinman speech in any non-crypto case. That's why he's emphasizing how unlike this is. Cryptocurrency is a relatively new and ephemeral concept as well. They will be given a chance to comment. Unless, of course, there was already a definitive decision made before Ripple got to it. However, should we anticipate that? That, however, is a digression from the subject at hand. I think Ripple will be successful in its fair notice defense at summary judgment even if the court rules against it, as Attorney Morgan predicts. To be clear, he's not expressing an opinion on whether or not Ripple will succeed on summary judgment in that sentence. Since this won't significantly shift public opinion, that's all he's saying. Also, and this is important, there are opinions from Attorney Morgan and Attorney Fred Rispoli and other attorneys in the XRP group, and they do indicate something that I've discussed before. But since we're discussing the seriousness of this filing, it bears repeating here. The judge's decision on fair notice, if it ever comes about, will depend on whether or not something catastrophic happens to Ripple and, by extension, XRP holders. Judge Torres will have to figure out what has happened with XRP sales by Ripple so far, at the very least up to the time the action was filed. You don't even have to address the problem of fair notice defense if it turns out that neither X nor P is a security and that no transactions from Ripple are determined to be infractions. That's why a member of the public going by the name of Tim just replied to Attorney Morgan, arguing that achieving fair notice does not benefit the average retail investor. So my initial reaction to reading it was something along the lines of, well, yeah, I mean, we already got really bad news regarding XRP, and that was my first thought. It's probably not going to have much of an effect on XRP anyhow, assuming the judge is even deciding that. In the past, Attorney Deaton has described it as more so like an insurance policy for Ripple. After receiving the email, Attorney Morgan responded that it meant Ripple had won the case and could move forwards with developing its service, which would raise demand for the value of XRP. Yes, that is assuming Ripple has an equal chance of winning. And then he adds that most XRP retail holders expect this to rise XRP's value and to their advantage. Yeah, so I can only speak for myself when I say that I believe it is beneficial for the XRP ecosystem to have a wide variety of developers working on top of the XRP ledger. Not that we can expect the price of Ripple to rise because of the efforts of a single developer, but if there is anything of substance in the cryptocurrency world, I believe it would have an effect on the market. It involves the entire ecosphere in its entirety. That's why decentralized systems exist. Naturally, we should anticipate real value in order for a price to rise, otherwise, we would question why there are any developers at all. Since the start of crypto, there has been a lot of wild conjecture, much of which makes no damn sense. There have been some wild things done, along with some absurd and unwise financial choices. In the 14 years since the invention of crypto, there has been no shortage. But I think that happens less frequently in a developed market. Plus, there was this. In response to Attorney Morgan's statement, someone remarked, this only applies if the Howey test is an adequate metric for cryptocurrencies, though. Right. Ripple doesn't need to win on the fair notice defense, which is what I was getting at just a minute or two ago. And Morgan stated, it is only relevant to the fair notice defense if Ripple wins on the Howey test, not applying to Ripple's XRP sales. Irish Tiger, another member of the XRP community, emailed attorney File, "Thanks for this, Jim, but isn't a fair notice defense by Ripple only triggered if they lose a substantive issue? I think the SEC is trying to impose a late settlement at this point. They may not even need to defend because even if they do, they still come out ahead. If Judge Torres finds that no investment contracts were ever created, then the lawsuit is closed," as XRP Clarity and attorney Fred Rispoli noted in response. Fair notice is relevant only if and when Judge Torres finds that a jury must evaluate whether or not any of Ripple's XRP sales were illegal. Additionally, there is this. Someone called Mark emailed lawyer Rispoli to say, "Oh, wait here. Actually, I'd like to go from the very top down here." Well, SEC just filed a notice of additional authority already fair notice defense from a Massachusetts district court case, although it's not super on point, Fred Rispoli tweeted separately. This could cause a delay in Judge Torres's summary judgment determination, as she typically allows the opposing party time to respond to such notices. Sigh. Mark, a member of the XRP community, reacted with a letter that they were able to draft in just a couple of hours. It's not any more of a stalling tactic than when Ripple did it lately. Solicitor Rispoli concluded his letter with, "Yes and yes. Neither the SEC nor Ripple has lost my trust with their recent additional filings. And you know, I honestly hadn't considered that, but you make a really fair argument. I've covered all of these papers on this channel, including Ripple's most recent additional filings, which might have theoretically influenced Judge Torres' release. Perhaps she still hasn't reached a conclusion on whether or not to announce a summary judgment. But what I'm trying to get at is that if she's at a place where the release is imminent and she's like, 'Yes, I'll just do it tomorrow,' then if she gets something new, we're like, 'All right, well hold on, let's tap the brakes.' I need to read everything, take it all in, and figure out if and how this affects my rule and how it might apply to this specific circumstance." The thought process would be exactly like that for her. So far, we have heard nothing from Judge Torres despite the fact that it has been at least a month since the last additional authority from Ripple. I'm going to assume that Judge Torres wasn't going to make a final decision right then. That's a pretty safe assumption on my part. However, if she was going to do so in this specific case, this may delay the SEC filing. That is the argument that Fred Rispoli, an attorney, presents. This also happened. "It's not mandatory that there be a hold-up," he wrote. "In the next 5 minutes, Judge Torres can have her clerk upload her decision. She has been patient throughout this matter, allowing the other side ample opportunity to answer. Even though Ripple may respond to this supplemental filing in less than 2 hours, it is still being filed." There you have it. So he's basically stating that if Ripple filed immediately, there wouldn't be nearly as much of a chance of a delay. However, Judge Torres's actions show that she has given both sides ample opportunity to respond. It's not necessary, but it's not unreasonable to think she may. But I will admit that it appears that Attorney Morgan disagrees with me on this point. And thus, Attorney Morgan wrote, "I wanted people to know that this will not cause delay and is not a binding precedent on the court in the SEC. The fact that in United States versus Commonwealth Equity Services, the judge in the district court rejected the defendant's reliance on Upton versus SEC, on which Ripple also relies, does not mean that Judge Torres will necessarily reject Upton versus SEC in favor of applying and following it on the different facts in the SEC. Shake the versus yeah." So what he's saying is that while there is some similarity between the events in the Commonwealth case and how Ripple is arguing that hey, Upton applies here, the facts and circumstances of SEC versus Ripple suggest that Upton may not ultimately play a role in the judge's decision, if any, regarding Ripple's fair notice defense. And then Attorney Morgan says that while the crypto market is in its infancy and there is uncertainty as to whether or not securities laws apply, it is worth noting that in the case on which the SEC relies, the failure to disclose conflicts of interest, which was the subject of the complaint, had been an industry-wide standard of conduct for 50 years. Yep, that brings up an issue I was discussing earlier in the clip. More uncertainty exists in this field than in any other field that has existed for more than 50 years. Now that we have someone who is conversant with the norms of that field, we can begin to understand what it takes to succeed there. And that's not the same thing at all. Both the specifics and the context are drastically different. Consequently, I do not believe that this will have any bearing on the things that are most important to XRP holders, such as secondary market transactions of XRP, some form of illegal securities infringement. Would doing so put you in violation of the law? That shouldn't have any bearing on the outcome, in my opinion. It's possible that this may have a negative effect on Ripple if things go badly for XRP holders, but I don't think it's very likely. But by then, it would essentially just be a Ripple. Here we have a member of the ZP community going by the moniker Crypto. Consuela chose this name in reference to Family Guy. I really like the lemon promise. Consuela gives Senator Hogan a rating between 1 and 10 in this letter. Is the judge aware that her ruling will affect the fate of an entire industry and the livelihoods of many individuals? This is a question that has long intrigued me. It's been a topic of conversation amongst friends and me here and there lately. And from where I sit, I think she does know. I agree that she is quite perceptive. It's as clear as a bell. It's never occurred before, but when around 76,000 XRP holders were represented by lawyer Deaton, it was truly unique. The number of amicus briefs is astounding. On the plus side, it's not simply that individuals are showing up to be the center of attention. We hope to be involved in this matter to this extent, with her permission. This isn't the only issue. That's the case. Perhaps it is, in fact. That is, in fact, a major part of it. It's not only that the general public is participating. Simply put, she hears what you say. That's the whole point, you know. It seems like she's paying attention. Since she was under no need to read any of this or permit any of these amicus briefs, she does wish to take it. Didn't have to give Attorney Deaton any sort of permission to act. And yet, she managed to pull it off. That's why I know she was a complete blank when she arrived. That seems to be the case, and I simply want her to know. So, Attorney Hogan retorted, I don't know, to be honest, she has obviously been cued in that this is not a usual case. This is why I'm more willing than Attorney Hogan to go out onto a precarious ledge. Not a problem. However, Attorney Hogan still agrees that Judge TORRES has likely been able to detect the unique characteristics of this case. One of these is definitely not the same as the rest. It's the Ripple case before the SEC, or something like that. There's also, this. If XRP sold in the past and today is constituted a security, wrote a community member named Dennis to Attorney Hogan. Is it true that you are entitled to all the privileges under the law? Do I have the right to represent myself to Ripple as a shareholder? I ask in all candor. And Jeremy Hogan replied, since that is an excellent inquiry. Unfortunately and ironically, Jeremy Hogan wrote no, of course not. We would have to go back and tell Ripple, hey, look at all these requirements of, all these illegal infractions right here, if we were to come to that kind of decision, and usually there's some sort of contract indicating additional responsibilities. It stands to reason that you would be accountable to the many people that possess XRP. Right. That's why it's so ironic when legal counsel Hogan argues Ripple wouldn't have any new duties. Not that I want them to be responsible for anything, it just doesn't make any sense to me. All I'm trying to say is that if anything like that occurs, it stands to reason that action must be taken at the scene. Right. For this reason, Attorney Hogan says, no, with irony. And thus, we've arrived. Nothing in this universe makes any sense. No, I don't give out financial advice. Nothing I write or say should be used as a basis for making financial decisions. Please like and subscribe my channel. See you in the next one, bye.